Hello and a warm welcome to Sarat Chandra IAS Academy, where your teams are our mission. This is Yatharth here. Today we'll be talking about current affairs as well as mapping. So let's begin with the first news, that is about the electoral bond scheme. So let's see what Supreme Court has decided on this scheme. So Supreme Court declares electoral bond scheme unconstitutional. That means it does not confer to the values depicted in our constitution, or it goes against the ethics of the constitution. So electoral bond, let us first see what was this electoral bond. So electoral bond was a mode of funding to the political parties in India. So obviously political parties, they need funds to operate, market themselves, as well as towards elections. All right, for promotion and various different things, or paying salaries of their employees. Okay, so for various things they need funding, and this funding has to come from somewhere, and this fund is significant. All right, it's in crores, multiple crores, so it has to come from somewhere. And multiple big companies, private firms, so they could donate this money to the political parties. Now this money donation was anonymous, and there was a rebate on the tax paid on this. Alright, so for this many private firms, let's say Reliance, Adani, and various different, these have been much accused in the past. So these were paying the political parties, okay, and were in, let's say, a profitable friendship with these parties. So this is why, this was the major reason because of which it has been declared unconstitutional. So let us know about this. The scheme of anonymous electoral bond was introduced in the Finance Bill of 2017 during Union Budget of 17-18. Finance Minister Mr. Arun Jaitley that time proposed to amend the Reserve Bank of India RBI Act in order to facilitate the issuance of electoral bonds by banks for the purpose of political funding. Okay, so this makes our first statement, that who was issuing the electoral bonds. So the bank was issuing, all right. And it was towards the funding of political parties. Okay, now let's move forward. So anonymous electoral bonds were introduced specifically as an integral component of the union budget and hence classified as a money bill to enjoy certain procedural advantages. So we need to see what is the difference between a normal bill and a money bill. Okay, what advantages are conferred to a money bill? What say does Rajya Sabha has on a money bill, or president has on a money bill, and how it is advantageous towards the Lok Sabha or the pertinent government. Okay, who can agree or disagree, or what changes can be made to a money bill? Alright, to enjoy certain procedural advantage and bypass certain parliamentary scrutiny processes in violation of Article 110 of Indian Constitution. So this is a violation of Article 110 of the Indian Constitution. Now let's see what is Article 110 of the Indian Constitution. Alright, just a second. So we'll put a heading, Article 110 of the Indian Constitution. So Article 110 deals with the money bill. Alright, so it defines that how can be a bill a money bill or declared a money bill in India. So various different section of this bill, let's say, talks about the imposition, abolition, remission, alteration or regulation of any tax. So if a bill does that, it can be classified as a money bill. The regulation of borrowing of money by the union government, alright, then it will be classified as a money bill. Or otherwise the appropriation of money out of Consolidated Fund of India. Consolidated Fund of India, then it will be a money bill. Or if any bill, let's say, declares of any expenditure charge on the Consolidated Fund of India or increasing the amount of any such expenditure. or if any bill talks about the receipt of money on account of consolidated fund of India or the public account of India, or the custody of issue of such money or audit of the account of union or a state, or any matter incidental to any of the matters specified above. So basically, any bill that talks about money regarding consolidated fund of India can be classified as a money bill. But this was not a money bill, this electoral bond one, as it violated the things specified in Article 110. Let us also know here only that Article 117 talks about the financial bills. Alright, so this is a separate topic. We'll read it someday else. Now let's talk about other things. So according to an estimated total of 18,299 electoral bonds, equivalent to a monetary value of 9,000, over 9,000 or around 10,000 crore, were successfully transacted during the period spanning from March 2018 to 22. So in 4 years, almost 10,000 crores. So about 2,500 crores in a year. So that's a lot of money. Alright, so this was donated to political parties anonymously by various different people or firms. So on 7 November 2022, the electoral bond scheme was amended to increase the sale days from 70 to 85 in a year when any assembly elections may be scheduled. Alright, so more and more donation was, let's say, required or demanded. It was such and such setup. Now in a landmark anonymous judgment now in 2024, the Supreme Court has struck down this electoral bond scheme as unconstitutional and manifestly arbitrary. The electoral bond scheme, which provides blanket anonymity to political donors, as well as critical legal amendments following rich corporations to make unlimited political donations. So, let's say, what is the profit when anybody donates money? Alright, why would anybody want their money to be reduced by a certain amount? Because when you are making a donation, the money is getting reduced. So why would anybody want that? Of course, in exchange of some sort of favor. So this favor plus blanket anonymity. What is anonymity? That nobody will recognize who has done this thing. Who, when, how, or how much. So this says, the Supreme Court says that this is completely arbitrary. Arbitrary means random, following no certain process or procedure, in fact. Alright, this is why it is unconstitutional. So not only it is arbitrary, it is also unconstitutional. Now a five-judge bench headed by Chief Justice of India D.Y. Chandrachud held that the Union government scheme and preceding amendments made the representation preceding means that followed later, such as increase of sale days or change in the RBI Act, made to the Representation of the People Act, the Companies Act and the Income Tax Act violated the voters' right to information about political funding under Article 19 of the Constitution. Furthermore, Chief Justice said that the absolute non-disclosure of the source of political funding through electoral bonds promoted corruption and a culture of quid pro quo. So what is this quid pro quo? These are terms such as bona fide, okay, quid pro quo. So it means something in exchange of something. So we'll give you money, you give us some sort of favor. And of course, if we do not know, if the voters do not know that who is donating, so we do not know who is being favored and by which policy of the government. You can see majority of ports now are operated by or under Adani. Okay, so how come so? Alright. So Chief Justice Chandrachud said that the absolute non-disclosure of the source of political funding, so it basically increases corruption and brings a culture of the quid pro quo with the ruling party to introduce a policy change or for bagging a license. Now let's talk about the next thing, that is corporations versus citizens. So the judgment bailed the cat on the deep nexus between money and politics. So the court said that contributions made by companies are purely business transactions made with intent of securing benefits in return. It noted that the scheme allowed for inflow of huge contributions by companies and multinational corporations with major business stakes in the country, overawing or even concealing the relatively small financial contributions of an ordinary Indian, the student, the daily wage worker, the artist, or the teacher who believes in the ideologies of a political party without expecting any substantial favors in return. So, this is right and wrong at the same time. Of course, a student, or let's say a teacher or a daily wage worker, so what are they donating actually to political parties? The economic condition of a normal citizen in our country is not so that they can even donate to political parties actually. All right, only the multinational companies or big corporations have the money to donate to political parties in a substantial amount that is actually significant. All right, and of course, some favor would be required by them in exchange. So, this does change the working principle of any government. But this has been the history through the ages. All right, it has been like this through the ages. Now, let's say if this scheme is unconstitutional, of course, there will be a different way find out in upcoming years to bypass this too. All right, because the market economy is such. So, but all these aspects are for our interview purposes only. For the answer writing purpose, we must note down that what is goes against. So, the one thing that is goes against is economic inequality. Economic equality, sorry. Furthermore, it goes against the ethos of one person, one vote. One person, one vote. Because here what's happening, the government may actually be changing some policies in favor of a single corporation or single person who has donated a large amount of money. Alright, so it is on the government's conscience to do or not do so because of this scheme. That is why it is unconstitutional. Okay, furthermore, what it goes against is voters' right versus the donors' right. So the court dismissed the union government's argument that the anonymity of political donors afforded by electoral bond incentivized financial contributions through banking channels. The court agreed that the fundamental right to privacy covers a person's political affiliations. However, there should be a balance between informational privacy and the voters' right to information. So voters do demand to know that who is paying the government a lot. The donation is basically payments made in exchange of some favors. Alright, so the donors or the basic citizens need to know that which person is donating how much, and is this correct that there is no balance between the government's decisions. Alright, so the balance is not there, and that is why Supreme Court has said that it is an unbalanced scheme which is favoring more the donors' right over the voters' right. Furthermore, Chief Justice said that a clear distinction between donations by corporates for favors and contributions by individuals as a mark of their political beliefs. Not all contributions are made to alter public policy. Contributions are also made by people to political parties which are now substantially represented purely with the intent of extending support. Contributions made for quid pro quo are not an expression of support. Alright. The last argument that the Supreme Court dismissed was the black money argument. The court rubbished the government's claim that the scheme was meant to curb the injection of black money into the electoral process. It ruled that curbing of black money was not a reasonable restriction to the exercise of the voters' fundamental rights to information about political funding enshrined in Article 19(1). Alright, so this scheme went against the usual will 1010, which deals with the money bills, as it bypassed the role of Rajya Sabha. Alright, and was solely dependent on the Lok Sabha. Also, it amended many acts in order to facilitate itself. Also, it created an unbalance between the one person, one vote ethics. That is why it is unconstitutional. Also, it is going against the Article 19(1). And privacy does not mean that something can change the policy making of the government. So the Chief Justice asked that the Union government how the absolute non-disclosure of the sources of political funding introduced in the electoral bond scheme could rationally help curb black money. Clause 7.4 of the scheme completely exempts information on the purchaser of the electoral bonds. This information is never disclosed to the voters. The purpose of securing information about the political funding cannot be fulfilled by absolute non-disclosure. Okay, last thing is hinged on anonymity. So, applying on double proportionality standards, the court said that the clause was unconstitutional as it did not balance the conflicting right to information of voters with contributors' right to privacy regarding their political affiliations. Alright, so we must be able to know that, let's say, Gautam Adani. So, this is a single person having a big firm, let's say Adani Enterprises. They have a lot of money to pay to the government or donate to the government via electoral bond scheme. Now government, let's say, takes a decision. It gives a tender to Adani. Okay, we need to know that whether how much money was paid by Adani to the government, and is this policy a result of this donation or not. Alright, so this is the voters' right to know, right to information. And this that they do not want to disclose that we paid this money is their right to privacy. Alright, but the exclusive or the complete non-disclosure of this information is completely unbalanced with the right to know of the voters. So clause without this, the scheme was indistinguishable from other modes of financial contribution, including checks, direct debit, and electronic transfers. Since the clause, the scheme had to fall. The original section 29C required political parties to publicly disclose contributions in excess of 20,000. That means if anybody, let's say contributor is paying more than 20,000 rupees, then they have to publicly disclose their contributions received even through checks and the electronic clearing system. The amendment, however, allowed a complete exemption for political parties to publish contribution received through electoral bonds. The amended section 13A also freed parties from the obligation of keeping a detailed record of contribution received through electoral bonds. So what does that mean? That there will be no records and no obligation to disclose. So it's completely making it an obscure thing with no record. Alright, so it shows something. Now before the amendment, section 182 also had mandated that companies could donate only up to 7.5% of 3 years of their net aggregate income. The amendment lifted this cap and made room for unlimited and anonymous corporate donations to political parties. The pre-amendment provisions had also banned government companies from making contributions to prevent them from entering the political fray. It had moreover classified loss-making companies and profit-making ones differently or separately. The electoral bond scheme, which was notified the government on January 2, 2018, introduced money instruments through which companies and individual India can donate to political parties anonymously. Alright, and we also know the underlying principle already, that it was more possible that loss-making companies would contribute to political parties with a quid pro quo and not with income tax benefits in mind. Let's say if company is making loss, so it will donate the money to government. The government will do something to put it again in the market and profit. The amendment to section 182 does not recognize the harm of political contributions by loss-making companies, for quid pro quo is higher. The amendment is arbitrary for not making a distinction between the profit-making companies and the loss-making companies. Okay, this news, the next one, why Sri Lankan Navy is arresting the Indian fishermen. We'll see in the next lecture, as this one has been long enough already for a single topic, and we'll cover more in the next lecture. This is Yatharth here. Thanks a lot for attending this lecture. I hope you understood a lot. Please make a mind map for this lecture. It will be around, I think, 1 page, and I'll send you the notes over the Telegram page as well. Thank you very much. Have a great day ahead.